Myth number 8, as it relates to criminal defense and DUI cases, is that the judge can make a plea offer, or that a judge in a criminal case can somehow have some type of power to dismiss a case unilaterally without the prosecutor or the defense attorney being involved. And if you send a letter to the judge, that somehow the judge could read that letter and then dismiss the case or take some action without the parties being present. And this is a feeling that people have mainly from TV shows where they see that the judge is heavily invested in the case and the judge is forcing the parties to go one direction or the other. Now in reality, at least in Maricopa County, the prosecutors have an awful lot of power. And the prosecutor is the individual who would determine what a plea offer would be. And the prosecutor is the one that you typically negotiate with. And the judge really isn't in the picture while plea offers are being negotiated. So if you're charged with a DUI, for example, your attorney would meet with a prosecutor and they would discuss options, and they would discuss whether or not a plea offer could be extended. Once that plea is extended and signed, the judge has to accept it. But the judges aren't typically involved in the plea negotiations themselves unless there's a settlement conference, and that would be perhaps in front of a different judge, and that judge would give them some type of input as to what they think is fair. But the person who's making a plea offer in a case is a prosecutor and not a judge. Those are the ones who are writing it and extending it to a criminal defendant for their signature if they want to accept it. So sending a letter to the judge at the beginning of a case, or wanting to a plea to the judge for mercy at the beginning of a case, is typically not something that's terribly productive, because the prosecutor, in fact, is the individual who has the ability to make a plea agreement.